And without further ado, Giovanna, please go ahead. The floor is yours.
Thank you so much, Théo. And good morning, everyone. Thank you so much for joining us this morning for this special occasion. I know there is a lot of reshaping work enthusiasts in the audience that have been supporting us along the way, but also many of you who strive to make future work better for all, whether through your research, advocacy, policy making, or business practices. Our report launch comes at a very interesting time for Europe. There are many developments in the policy sphere, but also technological development, advancements and socioeconomic developments that can be ignored. When it comes to platform work, the European Commission's proposal for a directive published at the end of 2021 was certainly a bold move and very much needed. You can say that all eyes are on Europe in a way. And while nobody objects that more protections are needed for platform workers, there are disagreements about the tools to achieve increased workers' protection. And that has been having the European Parliament divided over the past few months. In addition, we see AI being increasingly used at a workplace, another topic we need to address. The use of remote monitoring and surveillance tools surged 108% in the US and Europe in the first months of the pandemic. And I think that is concerning. It is threatening workers' autonomy, but also their well-being at the workplace. Furthermore, global youth employment dropped almost 3 times more than the adult employment in 2020. But unfortunately, the youth post-pandemic labor market integration is not our only concern. Their mental well-being is more of a concern. The pandemic caused 25% increase in anxiety and depression globally, disproportionately affecting youth and women. So a lot is on our plate, but not all is green. There are also many exciting things to look forward to with the new technologies, but also in regards to the platform work. So today here we are together to find these solutions. And in the Reshaping Work report, we already took steps towards that. Our report is an outcome of 8 months long discussions facilitated with companies, startups, unions, advocacy groups, and researchers. They've all had valuable information, insights, but also stake in these topics, which makes this multi-stakeholder approach paramount to achieving balanced solutions. At Reshaping Work, we considered all these different points and built upon our own knowledge and insight as we comprised policy recommendations to address these pressing challenges that I have just mentioned. So I briefly want to just highlight our main recommendations, which I hope will be a subject of the constructive panel discussion that will follow. So in general, based on the evidence we have to the date, it is clear that some workers are incorrectly classified as independent contractors while being subjected to various levels of control by platforms. Other workers, on the other hand, are genuinely self-employed, that is correctly classified and want to remain that way. We believe the protection is needed, but for all. Thus, we recommend that basic social protection, such as sick leave and pension, should be extended to all workers, regardless of their legal status. Second, we believe that employment status indicators have to be clarified, but without undermining the achievements in the case of law on the national level. And relatedly to this, what the current directive is currently missing is clear guidelines how to reboot the presumption of employment. So we believe a rule book is needed to clarify that for platforms, which will provide legal certainty, level the playing field across platforms, but also avoid lengthy and costly disputes that nobody wants to have. Third, we think the regulatory provisions on algorithmic management should be extended to cover all workers subjected to automated monitoring and decision-making, and not just platform workers. And this is really important because as much as algorithmic management seems to be pioneering by platforms, it is actually increasingly being used across businesses and sectors, many of which are traditional companies. So we need to make sure this covers all workers. Furthermore, on AI, there are a number of legal instruments currently in place, such as GDPR, and we shouldn't forget their role. But what is missing here is utilization by workers is limited. So we need to ensure that workers are properly informed of the legal instruments available in a way that is easy to comprehend. So for example, via toolkits and blueprints. We also think that auditing of AI systems should be mandatory. And this is not to punish wrongdoing, but to lead to better understanding of these systems, which are black boxes for many of us, but especially for workers who are affected the most. And finally, when it comes to youth employment, we want to highlight the need for good quality jobs to start with. Once we have that, we can move on to the upskilling and reskilling programs for youth, and especially by implementing private-public partnerships. When it comes to the education and upskilling and reskilling of youth, we believe it needs to be done on an ecosystem-wide level. So it's not just the responsibility of the public sector. And in line with that, we need to ensure the access to mental health support programs for youth, but also workers in general. So these are some of our key recommendations. They're not exhaustive. There are many more to be found in our report. So I hope this will motivate you to have a further look and give us feedback. And I also want to use this opportunity to thank Jelena Despina and Tiago for co-authoring the report, as well as all the participants of Reshaping Work Dialogue that shared their valuable insights with us over the past months. But now we move to the highlight of this event, the panel discussion, back to what truly matters in the future of work. So back to Théo to lead us into the discussion.
Brilliant. Thank you, Giovanna, and thank you for giving us such a broad perspective on the policy recommendations of your report. And really, this conversation ought to be quite a thought-provoking one, and frankly, a timely one too. And you've said this in passing, but conversations over platform workers' protection and algorithmic management in the workplace, they're incredibly prominent at the EU level as we speak. And just to give you a sense of timelines, I mean, that you probably all already know, but the European Parliament is set to vote on a compromise text this very Thursday, while council negotiations are ongoing with the hope of finding an agreement really anytime soon. So, to shine a light on those crucial matters that Giovanna's outlined, and to build on Reshaping Work's newly published report, I'm very pleased to present to you a brilliant panel. We've got Ana Carla Pereira from the European Commission. She's an advisor to Commissioner Nicolas Schmit on issues pertaining to employment and social affairs. And really, you're one of the key people behind the Commission's proposal for a platform workers directive. So it's great to have you here. We've got Klaus Heeger as well, who's the General Secretary of the European Confederation of Independent Trade Unions, or CESI. Rani, who's Senior Economist at the International Labour Organization, the ILO, who specializes in the digital economy, and I believe you've coordinated one of the ILO flagship World Employment and Social Outlook report back in 2021. And last but not least, we've got Samuel Laurinkari, who is Head of Global Public Policy at Wolt, a delivery platform. And I am Théo Bourgery-Gonse, a journalist at EURACTIV, covering, among many other things, platform work. A slight housekeeping announcement before we kick off. Feel free to ask your questions in the Zoom bar. I encourage you to put your name and organization with it so that we know where it comes from. And we'll turn to them eventually after a conversation with the panelists. Now, on to just to kick off the conversation, perhaps a bit of context setting, and I'm turning to you, Uma. Can you give us a bit of a sense of how prevalent this new gig economy is in Europe today? Whether the EU is taking the right steps in order to find the balance between protecting workers on the one hand and enhancing business innovation on the other, and in light of your experience, in light of what you see in Europe and elsewhere, what are the most pressing regulatory concerns, and what can we do to alleviate them?
Yeah, thank you so much, Theo, for these questions. I'd like to thank the organizers for having me and the ILO here for this discussion. I think in this particular discussion, it is very important for us to set the context and especially, to understand what platforms are doing. Now, I just want to take a few seconds to just explain that what platforms are doing in the space of the labor market today is they are mediating work using technology and sort of matching workers with either the firms when you're talking about online web-based platforms or with different types of clients and customers when you are talking about location-based platforms like taxi or delivery or care work or domestic work. So one needs to very clearly understand that there is work in the traditional labor market and platforms are coming and actually improving efficiency, as they might want to call, or trying to better match workers with clients. So there is a sort of a disruption in the traditional labor market. And I think this is very, very fundamental for us to understand, because there's always this notion that comes up saying that, oh, the platforms are the new business, are the new sector, and they're creating jobs. No, they are trying to improve efficiency, probably in the existing labor market. Where there's a possibility of work being created or generated are in two areas very clearly. One is, since the COVID-19 pandemic, what you see is the rise of delivery workers. That's one area where you can see a rise in employment opportunities for workers. And the second is, with the Web 2.0 coming in, you need a lot of cleaning and a whole lot of jobs that have to be done for ensuring that when you look for something on the web, things are very clean. So this is what is often called as microtask work, which is either outsourced to developing countries or done online across the globe. So, these are two jobs that are created. And that's the reason why I highlight that is because the report that Giovanna just talked about is also talking about youth opportunities. And I think this is something we need to keep in mind. Now, as far as the estimates are concerned, it's very difficult to come up with one, but the EU directive very clearly talks about a number that is about 28 million people who actually try to find work through digital labor platforms. And there is a projection that it would lead to 43 million by 2025. And our own report of the ILO in 2021 came about saying that the number of platforms have increased fivefold over the past decade, and that's increasing, though there is a lot of consolidation that is happening. So it is very true that work through platforms is increasing. The number of platforms are increasing in number, even if you look at certain categories. So it's very important to look at this issue. Now, there are a number of challenges that are there, and I think there is one estimate that comes out saying that 5.5 million workers are misclassified as self-employed in the EU itself, and they should be actually treated as employees. And that would mean that they would get all the work-related and other social protection benefits, as well as accident insurance to it. And I think this is what has led to a lot of debate as to what the challenges are, which is not only related to the employment classification, but it also relates to remuneration, low wages. And the third thing, which is probably fundamental, is the algorithmic management practices that it brings about, which has huge repercussions on their incomes. It has repercussions on the work intensity, on their occupation safety and health, and also has finally repercussions on having a work-life balance. So I think this is a context in which the EU directive gets into the whole issue saying, let's try to think about having better working conditions for the workers in the platform economy. And what the directive very nicely does is it puts three issues up on fold. One is a worker status misclassification. Second is that of fairness, transparency, and accountability in algorithmic management. And I think what's very interesting about it is it goes beyond the digital labor platforms. It talks about ensuring this kind of a transparency for work in the traditional sector. And the third issue that it touches upon is the enforcement of applicable rules. Well, I think the text which was not approved in December was a lot of compromise text. So one will have to see where one is in the next few days of what it looked like. But I think this is a very good step forward. At the same time, while there's a lot of debate around employment classification in Europe, I think in developing countries, the issue is much more about predatory pricing, especially in location-based platforms. And I think one thing I'd like to highlight very clearly is, even when one says that some might be genuinely self-employed, I think in the context of platforms, this becomes very tricky, because earlier, self-employed, individual self-employed could actually command the price for the service that they could provide. But today, with the global labor markets, where platform operates globally, there's a huge pressure on reducing prices. There's a lot of underbidding that happens. And I think this is something that is not really taken up, and this is a larger issue to take on. So that's one reason why we at the ILO have had a tripartite meeting of experts last October to basically discuss as to what kind of a regulatory mechanism that we need, which goes beyond the EU. EU is a very good step forward, but we really need to think in terms of platforms for a global regulation. While there was no conclusion to it, and disagreements relating to largely, the worker definition or the right of self-employed workers to bargain collectively, or algorithmic management versus governance of algorithms. But today there is a step forward, even at that global level, where we are doing a normative gap analysis and presenting it to our governing body in March. And this issue would come up for a discussion in the International Labour Conference in the coming years. So I think this larger context is somehow very important to get into this debate. Thank you.
Brilliant. Thanks, Uma. And thanks so much for giving us not just an EU, but also a global level context. And I think it's a perfect segue into turning to Ana Carla to get a bit more of an understanding of one part of the directive, which actually takes quite a bit of space in the report, but really also has become so politically sensitive in the past year, really, since the proposal's been out. And that's the conversation over the legal presumption of employment. And there seems to be almost fundamental disagreements as to how this ought to function. Now, some stakeholders have claimed that introducing criteria within the text to trigger the presumption marks the end of self-employment. That's one radical take. Others, including the Commission, claim that it is a necessary tool for social protection and to fight bogus self-employment, which Uma, you've touched on. And then you've got the European Parliament that's taken almost a radically different route and has decided to get rid of criteria altogether when it comes to the presumption, but add new criteria to guide platforms' rebuttal processes. So I guess it's interesting from your part, Ana Carla, to give us a bit of a sense as to, first of all, what is the clear objective and intention of the Commission when it comes to the presumption of employment? What was the original intention there? And to the extent that you can talk about it, because negotiations are still ongoing, obviously, as we near the stage of trilogues, how do you expect the Commission to bring these conflicting views together into a functioning whole?
Yes, thank you very much, Théo, and thank you very much for inviting me to this conversation. There's a lot in your question, so let me try to unpack, but I'll try to start with the beginning of why we have presented the proposal, and just a few key elements that was behind the reasoning, not necessarily on the text itself, because I think that everyone knows by now, but I think the description that Uma made of what platforms are and how they work and how the platform work is percolating in the overall in the labor markets is a fair account. That it was discussed before we presented our directive and still remains valid. So I think we all acknowledge the transformational element that platforms bring into the labor market because of this different relationship between the consumer, those that provide the service, the platform who triangulates this relationship. So there is really something happening that is empowered by technology, and very much questioning whether the way we look at work relationships is still valid. Now, when we discussed with ministers back in 2019, so before we presented the directive, all member states, all the countries said, yes, this is an issue. We need to come to a minimum common approach, because what we see is a proliferation of cases in the courts trying to bring clarity about these relationships that exist between employers and workers, platforms and service providers and so forth. So there was a clear understanding by the member states at the political level that this was an issue to address at European level. So not only addressing it at national level, Europe needed to come in. And at that point, it was also clear that our approach needed, on one hand, to preserve genuine self-employment, but also address the many cases of bogus self-employment or vulnerability of this misclassified, with a clear political guidance that we should not create a third status or a third category of employment, because where that exists, in fact, it creates even more confusion and more problems of the boundaries in terms of access to different labor and social protection rights. So that has been the political mandate that the Commission took, besides, of course, what was already in the political guidelines of this Commission, but a clear message. And a similar message came from the Parliament, calling for an EU instrument that protected working conditions of people working through platforms. So I think in terms of the political landscape, there has never been a question that we should be proposing something. It is a very important element, because it doesn't happen in all cases. Now, the second point is to say, okay, so what are we supposed at European level to address, knowing that there are a number of issues that are certainly the responsibility of the member states. And for example, in the report that was just briefly presented, one of the things to say, well, there should be social protection for all, regardless of the status. Of course, this is something that the member states can do regardless. They can have policies to protect also the self-employed. And we have in the past presented a recommendation exactly on this, to stimulate countries to increase social protection for the self-employed and for non-standard forms of work. So that is, let's say, a manual of work or of intention that can actually be addressed by the member states at their level. Now, having a proposal at European level there are two main elements. First of all, is an issue of protecting the working conditions across and making sure that we uphold social standards across the EU, bearing in mind that very often we talk about on-location services, but the work of platform is going beyond borders. So it is important to bring this element of fairness across the EU market, but also an issue of level playing field for the companies, because it is important for companies to know what are the basic rules that govern their activities in the EU, and that this is not a sum of 27 sets of rules, but there is a minimum common that allows them to operate in different countries with a certain level of predictability and certainty. Now, as I mentioned, one of our goals was to make sure that we protect the working conditions of those that are misclassified, but also that we respect genuine self-employment. And so the proposal of the presumption of an employment status, so the proposal we have made is constructed and around the idea that if there are elements in this relationship that are clearly elements of subordination, then we are presumably, because it's a presumption, in a situation of employment. And those elements are very much inspired in what the courts have been saying throughout time, even the European Court of Justice, on what subordination and what a worker is across the EU territory. So those criteria that we have presented in our proposal are, in our view, a way of having a proportionate approach to be able to respect genuine self-employment, but on the other hand, being able to detect whether there is a misclassification, and as I said, inspired by jurisprudence. The other thing we also put in the proposal was this idea of a rebuttal. So you have a presumption. Our intention with our text was to say this presumption should give enough stability for the actors to perform their activities, and authorities at national level should be able to rely on this presumption to interact with economic actors. But of course, if someone does not agree on the results of the presumption, there should be a mechanism to rebut that. And at that level, at that second step, what we propose is to use the national definitions of workers that exists in each member state, and that those national definitions would be used then in the national courts to be able to finally decide if there is or not an employment relationship. I think these two steps, separate steps, are in our initial intention extremely important, because one, the presumption is really to decrease the level of litigation, to bring a certain proportion approach in the way we deal with the issue, while the rebuttal is really about going to court and really, hopefully, diminishing those cases and having at that point the national definitions of workers coming in. Now, as you said, Théo, this is in discussion, in negotiation, and both co-legislators have taken slightly different approaches. We in the Commission, we like to think that we are always in the middle, and as Aristotle said, it's in the middle that we find the right truth. But okay, we will see how the jury is still out, and we will see how it unfolds. But I think fundamentally, I think the important thing is that in the discussions that are going on both in Council and in Parliament, we need to first say what is good about it before talking about the dissent. And the good thing is no one questions the figure of a presumption. And I think that is an essential step. Now, of course, there are different views of how the mechanism should apply. And of course, you know the text that will be voted in Parliament, and you know that the Parliament proposes that the presumption applies to all workers, and then criteria is triggered more at the level of the rebuttal. In Council, the discussion is really about how many criteria need to be observed in order to trigger the presumption. So it is more, in a way, so the discussion that is ongoing in Council is more about making the presumption be triggered, or making sure that the criteria that trigger the presumption are a little bit more stringent, and there are different political views, and this is one of the reasons why the Council is still trying to find its general approach. So as you can expect from me at this point, I can only support the Commission's approach, which we think it's a proportionate one, and which we think will, in a way, decrease litigation at the presumption level, will help authorities have and the different actors have clarity. We would have criteria that is common across the EU, but then also allowing the national framework, the national notions of workers to play their role at the phase of the rebuttal. So at this point, I cannot comment more than hoping that the co-legislators on each side find soon their own proposal, so that we can soon enter in trilogues. Because one thing is clear for Commissioner Schmit and for this Commission, this directive is needed. It is needed to enter into force soon. Sure. So it's really important that we find the time and the space for trilogues to reach an outcome still during this legislative mandate. Thank you.
Sure, thank you, Ana Carla. And you're right to point out that actually the basics of the Commission proposal have not been challenged. I think the nitty-gritty of the number of criteria and the nature and the drafting of the criteria has been under scrutiny. But the general idea has remained the same. And in fact, in an interview with EURACTIV back in December, Commissioner Schmit did welcome the final sort of state of negotiations at the time of the Czech presidency, where we're getting closer to something that made sense to the Commission. So whether or not this will eventually work, it remains to be seen. But it's quite interesting that the fundamentals haven't been questioned. Now moving on to Klaus. I've got a two-part question for you. The first one is, you said, I did a little bit of internet searching, as journalists do these days. And back in December 2021, following, I think, on the day of the publication of the Commission, you said that, I quote, "Your voices had been heard." Now, if you fast forward a year and a bit, I wonder whether the text is still going in the right direction for you, and whether there's still remaining concerns from the perspective of the trade unions and the CESI. And I think additionally, and Ana Carla and Uma talked a lot about social protections independent of the contractual status of the worker. And I think what we're seeing with the gig economy is that there's almost some kind of paradigm shift in the EU labor market, where we move from full-time employment to a contractual relationship, which allows for more flexibility and autonomy. I guess, in your view, how do we make sure that we retain high levels of social rights for all workers, irrespective of the type of contract that they sign?
Yes, hello everybody. Thank you very much. It's a pleasure to be with you. It's a pleasure to see the results also of this reshaping work initiative. I think it was quite impressive, and what we like very much. And I'm turning to those. I mean, you're all on my screen, very tiny little points, but those who have been working, Ivana and Elena, above all, on this fabulous report. So thank you very much. I mean, first of all, we said our voices have been heard, because I think I can only repeat what Ana Carla said. A legal presumption was something which was, according to us, urgently needed. There were court cases popping up left and right in all different member states, most of them saying, for instance, when it came to Uber delivery drivers, that those were to be classified as workers, but there was not, let's say, a general framework which would which would enshrine a little bit these principles. And let me just take one step back also, because what Uma said, you spoke about disruptions, and I think sometimes, I mean, we have to realize that I mean, here I made some notes, of course, the distinctions between employed and self-employed is increasingly blurred. The traditional, how could I say, dichotomy between employer and worker is challenged by a 3 and more party arrangements, and new legal concepts and frames may be needed to conceptualize new forms of very complex work relationships. So at the same time, we know, and this is very clearly established in the Commission proposal, in the Parliament's position, and this is known to everybody, that when you have an employment status, you are better off in terms of labor law protection, collective or individual, and in terms of social protection coverage. So yes, let's say we were happy in a sense, because they were, unless under the condition that 2 of the criteria were fulfilled, that one could legally presume that there is an employment relationship. So now the question is, in how strong will this legal presumption stay, or how many criteria, to many conditions will it be tied? And as you said, you have the Parliament's proposal, you have the Commission's proposal. I think the Parliament's proposal is, of course, the stringent. I mean, we have been supporting that. We are trade unions. So, but where is the discussion right now in the Council? And there we're a little bit afraid, of course, that too many conditions will be tied to that legal presumption. That is one thing. Now, you say, how do we ensure, let's say, that the rights remain the same for all workers? Now, I think if I have an answer to that, you can canonize me after today's meeting. But I think I would start with the 4 general key elements, which, according to us, would be absolutely decisive. First of all, is, of course, let's say, a strong directive, as I just said, that is being adopted, and then 4 further elements: the application of certain provisions of labor law and classic social protection schemes to all workers. I don't want to go here into the discussion of the 3rd category, because I think we may go too far in here. But I think also in the report we see quite some good approaches here in terms of guaranteeing certain social protection schemes to all workers. Then we have the effective interest representation, out of which, or to which, belong then also social dialogue and collective bargaining. And I think also we had yesterday this pre-discussion also, it's very often the case, and I think in the report there are very good examples also, that on the ground practical solutions have to be found to protect workers. Now, what I think is really interesting when you look at the directive, because when you say the application of certain provisions of labor law and social protection schemes to all workers, first of all, we're all aware of the guidelines, which have been also published on the application of EU competition law to collective agreements regarding the working conditions of solo self-employed. And then we have the chapters 4 and 5, transparency and remedies and enforcement, which to my mind really is some kind of playing ground for an effective interest representation. I mean, this is hardcore, which you can see there in the chapters 4 and 5. And I think here there's a big possibilities really for workers, regardless of their status, to unite, to defend their interests collectively with the help of their representatives, with the help of trade unions. And so I think this is why we were happy, we're kind of happy with the directive. I mean, to make a trade unionist happy, that takes a lot. And we are just afraid now that these legal assumptions will be diluted to the extent that, because we also believe that the directive has some kind of, it has a legal, of course, effect, but it also should have a societal impact on all the actors concerned to say, well, we have maybe to consider this or that element to protect the workers. So to summarize, a strong directive, a strong legal presumption, the application of certain provisions of labor law and social protection schemes to all workers, effective interest representation. There are very many examples also in the report, social dialogue and collective bargaining, and last but not least, practical solutions on the ground. And I think they're very, very good examples for that. I think I would leave it at this point with it. Thank you, Théo. Thank you very much.
Thank you, Klaus. And this is actually a perfect segue into talking practical. Samuel, I want to get the conversation moving forward a little bit and not just spend too much time on the social protection and employment status. I want to move on to algorithmic management. And the reason why I waited for you to ask this question is because Wolt has actually been quite proactive in thinking and talking and publishing a piece on algorithmic transparency and how it impacts your day-to-day life as a company. Now, the Commission and Uma and Ana Carla have spoken a bit about this. The Commission's proposal sets out clear goals and objectives that touch on furthering transparency and accountability in algorithmic management. That may obviously affect workers' responsibilities and tasks and remuneration, etc. Can you perhaps first of all shine a light on how the algorithmic management works in practice at Wolt, and the extent to which this piece of legislation actually would impact your day-to-day functioning? And frankly, when it comes to this question of algorithmic management, is the directive good enough?
Yeah, no, thank you, Théo. And maybe I'll just I won't bore you with any corporate blurbs, but quickly introduce the company for those of you who live in countries where we don't operate. So Wolt is a local commerce platform, and we operate in 23 countries around the world, and 16 of them are EU member states. So we are no other platform operates in more EU member states than we do. So we feel like we have a certain legitimacy to speak on also EU policy topics. I also want to apologize for the bad lighting. I work in inhuman working conditions. I'm currently in Brussels in a shared office space in a booth that has no chair. So if I paint, why that happened. But yes, so I think maybe to explain our take on algorithmic transparency and transparency more broadly, I could take it maybe two steps back. And as has been recognized by some of the speakers, sort of like what platform technology and mobile internet created around 10 years ago is this kind of fundamentally new type of work where people can come and go onto online platforms as they wish and see what kind of tasks are available and then choose freely what kind of tasks they want to perform. And that's also the model that our self-employed model is built on. So we have self-employed courier partners that can take their application on the phone whenever they want, log on to onto the application, and then have delivery tasks offered to them, and then they can freely choose which ones they accept and which ones reject. And of course, that is an unprecedented level of flexibility in the labor market, which we see that is a fundamentally a positive contribution. And then I'll come back to what needs to be fixed about it, of course. But we've seen, of course, on the one hand, society welcoming this kind of new type of work that it's contributing to the labor market. On the other hand, we've also had a lot of criticism and societal debate what platform work is and whether it needs to be whether it needs to be fixed to some extent, and if yes, then how. And we've seen a lot of criticism about sort of exploitation of workers, about algorithms managing platform workers, and we feel like we didn't quite recognize our model in that debate. We've seen, obviously, we follow very closely what our courier partners think. We have regular service, we have focus groups and discussions, and our general understanding based on the data we have that our courier partners are very satisfied with the work they're doing with us. They're very satisfied with the compensation. The compensation is at competitive levels, and we see also that the way our platform works and the algorithm works is fair and non-discriminatory. And we feel like what we can contribute to the debate is being transparent. So obviously, in any proper legislative regulatory debate, we need a lot of facts, and we need transparency from everyone involved in those discussions. So we felt like probably a good place to start and increase the level of transparency and maybe debunk some of those myths with regard to the technology that's used by companies that was to publish a algorithmic transparency report. Then we published our first version of that last year. And so what, as part of like also the criticism towards platform work and the discussion about the correct classification, we've seen questions about, you know, whether or not platform workers are being punished by the algorithm, whether the performance is being monitored, whether people have equal access to working opportunities depending on their behavior, whether people have generally the right to reject tasks, or whether rejection of tasks actually leads to poor allocation of tasks. And we were trying to be transparent and open about the fact that our task allocation algorithm looks basically into three different things: the location of the courier partner, the location of the merchant, and the location of the customer, and then offers the delivery task to the courier partner who is best placed to take the task. If that courier partner reject the task, then to the second placed person. So it does not in any way take into account previous performance or whether or not courier partners have been rejecting tasks or how much they work. Courier partners can come and go as they wish, indeed. So doing 2 deliveries today and then go then be offline for the next 4 months and then come back and do a full week of work, or come every Friday for a couple of hours, or come every day and use our platform as a main source of income. And actually, quite interestingly, what allows this kind of completely neutral way of running a task allocation algorithm in the sort of platform work context is the fact that you have a self-employed model, which allows people to come and go as they wish. So maybe just quickly commenting on the few points that were made earlier in the discussion, we see a lot of, and in the discussion we've had in the last couple of years is that employment is often seen as a sort of single gateway to protections, and this was raised in many of the interventions before, and that's certainly right. With employment bring individuals certain protections that are not available to self-employed in many of the countries in which we're operating as well. But I think it's important to look at this more holistically, that you have essentially 2 different models. You have an employment model, and then you have a self-employed model. Employment in the platform economy looks like employment in any other sector of the economy. It looks like you have a shift, you have an obligation to be at a certain place at a certain time, you have a manager and managerial supervision, you're being told what to do and when to do it, and when a task is being given to you, you have an obligation to perform the task. And you do that in exchange of the compensation you get for your time commitment. Now, self-employed model, fundamentally different, right? As I described before, self-employed models are built on people's fundamental entrepreneurial freedoms to decide when to work, which tasks to accept and which to reject, the right to use substitutes, and the right to work for any other company at the same time. So these fundamental entrepreneurial freedoms that have also been recognized by the EU Court of Justice in the Wolt case on self-employment. Now, this kind of idea that if we were to force everyone into employment, then people would have better protections and everyone would be happily living ever after, fails to recognize the fact that these are fundamentally 2 different models. Employment also means exactly what I described. It means shifts. It means being at a certain place at a certain time. It means being under managerial control. It means performing the tasks that are being given to you without the right to reject tasks, without the right to work for the other companies, etc. So while both models have pros and cons, and we need to look at this holistically, and as part of it, what matters as well is what the people who actually perform the work want. And as mentioned in the discussion we have with our partners in the surveys and the external research, the message is clear. The overwhelming majority of couriers are doing this kind of work exactly because it allows them to come and go as they wish. And quite many would stop doing this kind of work if they wouldn't have that flexibility. So fundamentally, we feel addressing the concerns we as a society have about platform work by forcing people into rigid employment against their will is not the right policy choice. And there we see a path forward, an alternative gateway, maybe to use as if I've said that people see employment as a single gateway to better protection. There's an alternative gateway to better protection that allows people to maintain the flexibility they want, with the protections they deserve. And that there the Commission has taken great steps forward already, for example, by allowing collective bargaining for self-employed, and also including in the Platform Work Directive proposal in recital 23 the principle that if a platform offers better protections, it shall not be seen as elements of control. So we see this as building blocks towards an alternative gateway to protections where people can still have the flexibility they want, but have access to better protections. Quickly, my second point, maybe on the commenting on the previous intervention, is this concept of triangularity in the platform economy. I think everyone referenced the triangularity in the platform economy, and we feel like this focus on triangularity has misguided the debate, and it has misguided the legal drafting of the directive. So it is true that some platforms have this model that intermediates between someone who provides work and someone who buys the service, and the platform sits as a triangular party on top, and maybe through the terms and conditions can even exert control to the extent that it's been deemed to be the employer by national courts. And a lot of these court cases naturally have been dealing with these triangular relationships, and then finding these elements of control have been essentially the court's way to identify or showing that the triangularity is actually that there's actually generally no triangularity, actually there's management or control element by the platform. Now, all of that discussion may be right and may have merits, but that doesn't represent all platforms. So for example, we have a model where our courier partners are not offering services to the customers on our platform. Our courier partners are offering the delivery services to us as a platform. Mm-hmm. So that leads then to the fact that the criteria that the Commission, for example, has included leads to many false positives. So obviously, in a relationship where we buy a service, we'll have a different, we'll, for example, need to have certain hygiene standards that we require from our courier partners, without that being an element of, without that being considered an element of control. So that's one thing that I think needs to be like considered and make sure that this piece of law, which is incredibly important. We've been very supportive from the very beginning. We need legal certainty. We need improvement working conditions regardless of classification, and needs to be also future-proof and work for all kind of different business models.
Great, thanks, Samuel. I want to get Ana Carla to actually respond to a few things that you said, because it's very interesting and obviously a slightly different take to what we've heard so far. Before I do that, though, I'd like to go back to what Giovanna was saying. One of the findings or policy recommendations is to encourage companies to run an auditing of their own algorithms and their own black boxes. This is ultimately something that is very often misunderstood, hard to explain. Is it something that you see as possible as a delivery platform yourself? And how do you imagine working with public authorities in ensuring that level of transparency in the algorithms that you use, when in fact the black boxes sometimes can be so confusing that even their own creators fail to understand how they function? Samuel, the question's for you. Whether you think auditing is actually a possible way forward to enhance transparency.
I'm horribly sorry, I wasn't listening. I was reading Martin's question on the chat, which is also, I think it has like auditing element, but I think absolutely it is worth considering. Of course, we need processes where everyone in the sector buys in, and we obviously have been sort of already taking steps voluntarily and see why we couldn't formalize these processes and make sure that we also share this data in a transparent manner through third parties, also with authorities. I think is important that, for example, the European Commission has good data on which it legislates. So I think that as such is something to consider. And maybe while I'm speaking, also address Martin's question. I think a great one on whether or not sort of idle time is at the risk of the ones who perform the work. This is something, the way we addressed it as a company, indeed our compensation model is based on pay per task, or you get compensated per every task you choose to accept, because of the fact that you can freely choose which task to accept and which to reject. Having said what we try and balance is the volume and the people on the platform. So be careful about, like, we don't allow everyone to partner with us, because we want to make sure that when people partner with us and then go online, there's enough work for everyone. And we actually we track query compensation on a per online hour basis. So we look at how many what queries are making in average per every online hour, and that includes idle time. And we see very high levels of compensation across markets. And maybe I'll do some pre-advertisement here in the second transparency report we're working on is earning transparency. So we want to be transparent on how that model works and on which level the compensation is.
Great. Thanks, Samuel. Ana Carla, perhaps back to you on algorithmic management in the context of the directive, and what Samuel was speaking about, this idea of control, and to what extent do we misunderstand, I guess, the concept of control in the conversation of the gig economy.
Yes, thank you. Well, do we misunderstand what control is? I mean, I think, to be honest, the courts have been saying what control is. We didn't come up with anything new. So this is something that over time and through the implementation of the acquis, the European Court of Justice has been consistently and systematically saying what subordination is, and therefore what control is. And there are a number of parameters that are very regular despite the different situations. They always come as elements. So I think there is no such thing as ambiguity what control is. Now, I think what is maybe different here is the untransparency of who exerts that control. And of course, the fact that there is an algorithm, and algorithms are intrinsic elements of platforms. Of course, it creates a sort of unclarity for the person performing the tasks. In fact, who is exerting control? Because if you're not able to determine your rate, your price, and that is a fundamental element of a genuine self-employment, you need to start questioning, is there control or not? And maybe there isn't, but maybe there is an element that needs to be investigated. And I think the issue of having technology exerting that control is actually something new, and some said not exclusive to platforms, and we take that certainly. This is the use of algorithms and other techniques to surveil work and to control work are beyond platforms, but it's clear that the functioning of a platform is related to the existence of an algorithm. And this is the reason why this was so essential to have it in this directive. Now, what we do in the algorithmic part of the directive is really to say, well, the existence of an algorithm is actually affecting not necessarily in a negative or positive sense, but it's altering working conditions. And if that influence affects the minimum rights that people have on certain working conditions, then people should have the possibility of contesting the decisions of the algorithm. And to do so, it's necessary to have human supervision. And to do so, it's necessary to have transparency in relation to the algorithm, and to do so, you need to have remedial action if the decision has some sort of wrongdoing, right? So these are the elements we have embedded in our proposal. We did not include the creation, for example, of an authority that audits algorithms, as it was mentioned here. It doesn't mean that countries cannot do it. Because of course, when we talk about a directive, we are talking about minimum standards, and countries can always go further than what the text proposes. But what we wanted to convey through these provisions on algorithm is that the existence of the algorithm does influence working conditions, and therefore it's not just about data protection, it's not just about what already exists in terms of personal data protection in GDPR, but there are conditions in the world of work that are just part of the fact that normally companies have more power than a single individual, and that's why there exists labor law to protect individuals. And we felt that we needed to go further than the GDPR to be able to have clarity on how the algorithms work in the workplace for platforms. Does this exclude a conversation about the use of algorithms outside platforms? No, it doesn't. That conversation has a legitimate place in the policy debate and should happen. And we are certainly happy to engage with all the actors that want to talk about it. But it was felt when we presented the proposal on this directive that first of all, it was necessary to have a clear scope, a coherent scope in all the chapters of the directive. And second, that we were not yet in the condition in terms of facts and evidence to bring a proposal that covers the entire labor market on algorithms. So I think that question is there, obviously, and we are not oblivious to this, but it was necessary to also have a text that is consistent in its different elements, and the scope here is really about platform. One thing I would like, nevertheless, to rebut, if you allow me, of what has been said, is this idea that employment equals inflexibility and flexibility equals self-employment. If that would be the case, then it means that most sectors that are employment-based but have different working hours, work on shifts, work on tasks, they would not have the capacity to adjust, and yet that exists. So I really want to debunk this notion that in order to be flexible, you need to have self-employment. So I think I'm not saying that self-employment does not bring flexibility. I would like to be clear on this. I'm just saying that you can also have flexibility in an employment model. So I leave it for the moment.
Yeah. Thank you, Ana Carla. And Uma, I've seen you nod actively. Do you want to add something to that?
Absolutely, Theo. I think the last point that Ana Carla said is what I wanted to pick it up, saying that this notion that exists that the platform gives an alternative employment model needs to be debunked. Because if you really look at data coming out of ILO, coming out of OECD, you very clearly see that non-standard forms of work have been increasing over the past 3 decades. So, you know, all that flexibility that you want to talk about, whether it is part-time, whether it is temporary employment, or whether it's fixed-term employment, all of that, or, you know, zero-hour contracts that we talk about in the UK, all of that is existing in the labor market as part of the larger employment model. So, you know, you don't need to get out and say, here's a new model that comes in and brings in flexibility. Talking about the control, subordination, flexibility, I think there's one more thing I do want to raise, and this is from my experience from developing countries. So, you know, when you're talking about whether it's a taxi driver or a delivery worker, much of these workers in developing countries are part of what we call as the informal economy. They are self-employed. Now, they had everything that the platform advertises: freedom, flexibility, control over their work. But now they have joined the platform, and actually they have lost all the three, because now they are under the control of the algorithm. The algorithm decides which passenger to take or which delivery to take. if you decide to refuse a particular right, you don't know, you might not get any access to work for a couple of hours, days, or you can be completely deactivated. And the platform decides what the price of that right is. Now, it undermines some of the regulatory mechanisms that exist in many of these countries, where you have either the local municipality or the state federal level deciding what the fair right of the fair is going to be. So, it basically questions a number of things that this model actually brings about. And I think what I would like to say is that you are subsidizing consumer in this entire process or firms at the cost of the workers. And I think that's something we all need to bear in mind. And what the regulations are doing is trying to bring about some equity and distributional issues back into the fore.
Brilliant, thank you, Uma. Samuel, do you want to go for a quick response?
Yeah, just a quick one on the flexibility. I'm sure that also in different employment models offers certain level of flexibility, for example, on the side of the employer, indeed, to dictate different kind of shifts to their employees based on 0-hour contracts. But it needs to be borne in mind that we're talking about a completely different level of flexibility where you can come and go as you wish. So we don't know which one of our core partners will ever appear on our platform again. So people can indeed come for one delivery, log out, be somewhere else for 5 months and then come back and do a full week of work. And that's simply not possible under employment. And for example, already the EU Working Time Directive precludes this kind of flexibility in employment. So I think it's fair to say that there's some level of flexibility in employment, surely, but it's completely different level of flexibility that self-employment allows for.
Brilliant. I appreciate that this is, of course, a contentious and very exciting conversation to talk about, but there is one aspect of the report that we've not talked about at all. And Uma, in her context setting presentation, did say that we ought to talk about it. So I just want to spend a couple of minutes on it. And Klaus, maybe turning to you, there is this conversation about youth employment. And I guess my question is, how does that, first of all, fit within the broader gig economy world? Is it a right and fit place for young people who are just entering the labor force to get into this gig economy? And again, going back to what we were saying, how do we make sure that social partners and trade unions support and make sure that they represent the rights of all workers, including the youngest ones?
Yeah, thank you very much, Theo. Maybe also to give a short follow-up also to the previous discussion, to these conceptions, or Samuel was speaking of the misconceptions of platform work, and maybe following also the intervention of Ana Carla and Uma, we could also say that sometimes there's a misconception of work, of employment. So when I hear that these young, and that brings me to the subject, these young people think, oh, that would be terrible to be locked up in the cellar of a, I don't know, Charles Dickens-like factory for 5 days. Yeah, that's a notion of work you can have, which might not be, how could I say, which might be, and then I think also there are quite some interesting studies, for instance, about how deliverable riders perceive trade unions, for example. And so that to say that's some kind of general saying, well, we are young, we're independent, and we take work wherever we want and for how long we want. And this brings me back to what I said at the beginning also. Of course, this is totally legitimate, and we don't want to kill any business, etc. But we must think of the young people. We must, I mean, many people take up platform work, and this is also a first stepstone into the world of work. And this should at least also lead to the possibility of, at a certain moment, to take up standard employment. So that means we speak about pay, we speak about working conditions, we speak about skilling, upskilling of the youth force, we speak about employability, etc., etc. I refer here again also to the report. I think there was this co-op initiative mentioned also, which was some kind of cooperative initiatives, which also saw the day of light already, if I remember well, in the 2008 and 2009 years. And I think this is now a very crucial moment for trade unions also to help young workers to step in the gig economy. Of course, they are the gig economy is the perfect economy for young workers, but to make sure that certain in French you would say garde-fous, are established. And here I think we have Australians also fundamental role to play. Well, you know, we are usually the old schmucks, you know, old models and always angry, as I said, but sometimes to really become more open to young people, to have also internal, how could I say, organization structures which represent young people, which understand the logics of platforms, the logics of social media, and to really also react or to act as individual advisors and counselors, in addition to, I would say, the interest representation, or the collective interest representation. So I think, so to answer once again the question, yes, the gig economy is fit for young workers, but they need to be accompanied, and I think quite strongly, quite seriously, let it be by trade unions or let it be by other cooperatives, I would put it that way, to make sure that they're really stepping into a world of work, of not precarious work, of predictable work, of, let's say, employment, which gives them a certain perspective for life.
Thank you, Klaus. And I just want to close. I want to dedicate some time to Q&A as well. So there'll be my last question to go to Ana Carla, and to perhaps wrap it up on this question of general employment and reskilling, and specifically on youth. I mean, I think the Commission's 2022, there was the Commission's 2022 year of youth. We've now moved to the 2023 year on skills. What's needed in the context of youth and youth employment at the Commission and European level to, as Klaus said, foster youth employment, all the while ensuring high social rights, social protection.
That's yet another interesting, very relevant, but difficult question. I think one important element in this discussion is that there is absolutely no one from north to south of Europe, east to west, from different political groups, all different generations, that questions the need for more investment in skills. I think the issue is what skills and who delivers and who pays. And the Commission, with its activities, the European Skills Agenda, and now with the European Year for Skills, is really trying to put the spotlight on this issue and trying to bring actors together. It does also put money on the table that is very much channeled via the RRF or the cohesion policy instruments. But fundamentally, this is, the area of training. It is a responsibility of member states, and it is an area where responsible employers are doing a lot, but maybe it is not yet common practice across the different sectors and across the EU. And of course, we also need to acknowledge that for example, small companies, is not so easy to invest in training outside the job. So there is an issue of course, investment and support, but also an element, broadly speaking, of awareness that at company level an effort needs also to be done in investing in skills. Now, I think what we can say is that through the Pact for Skills that the Commission has launched 2 years ago or 3 years ago, we have actually rallied a lot of interested and willing partners. So it has become sort of a coalition of the willing, if you want, in saying, well, we are committed into this agenda, and by their pledges, I think we are above the 6 million people to be trained, and this is, an important effort, but clearly just a small part of what more can be done. Because when we look at the figures of digital skills, of literacy skills, of our capacity to adjust to green technology, for example, there is still a lot to be done. And this is the reason why the Commission puts the spotlight on 2023. Now, obviously, there is an intrinsic relationship with youth policies, but I would also like to say that the situation of young people in the labor market, and very often the precariousness that they are confronted with, is not just an issue about skills policies. It is also an issue about the terms of contracts that they are offered, the level of pay. I mean, there is a whole big discussion now about whether traineeships should be, we should ask for payment in traineeships, and that should be a compulsory element, remuneration of traineeship. So the precariousness that young people live now in the labor market is related to skills, but not only. And I think that this is an important element. It's important to consider that there are other issues that need to be tackled alongside the upskilling aspect. Because in many countries, the young people are the most skilled generation ever. So why is it that when coming to the labor market, they face certain conditions? And I think this is an heritage in many ways of how Europe dealt with the financial crisis of 2011 and how precarity became just the new normal. So hopefully now we have a different political narrative, and we are slowly shifting to a different model. At least this is what my commissioner is engaged to do.
Brilliant.
Thank you.
Brilliant. Thank you so much, Ana Carla. And thank you, everyone. I want to turn to the Q&A. I can see that there's been a parallel metaphysical chat whilst this conversation was ongoing on the bar. But there are a couple of questions which I'll be picking up as they came. There's no clear logic to them. One is from Théo Bourgery-Gonse, who says that we're missing the views of platform workers when it comes to these kind of conversation, and he's concerned that rules and directives are designed top-down and workers' perspectives are missing. And so it's a question to Ana Carla, actually, whether the EU directive, in the process of drafting it, whether you consulted with any actual workers before the suggestions were put forward. Ana Carla, very briefly, have you talked to workers?
Yes, very briefly. Yes, we had consultations with obviously trade unions who represent workers, but also associations of workers that clearly perform their activity. And we had those contacts in a structured manner, but also every time someone reached out to us, we have certainly taken the time to listen. So the proposal that you see today is actually a reflection of that consultation process of what we heard from workers, but also from platforms and other employers.
Okay. I've got another question now from Emma O'Mahony, who said, be interested to hear the panel's opinion on the trajectory of the file over the coming years. It's more of a political question. With Sweden and Spain having diverging views on the directive, how will this impact the final text that will eventually enter into force? I'm afraid, Ana Carla, this might be one for you again.
Yes, well, I think so far, the feedback we have and the indications we have is that all presidencies, the ones coming and the current one, are committed to take forward this file and this initiative. So we are confident that before the end of this legislative mandate, before Parliament goes into election mode and the college in the Commission finishes its mandate, that we will have an adopted directive that then enters into force and enters into transposition. So I think all the elements are there to happen. Of course, for this to happen, of course, the questions are, in terms of the details, as we talked before, where we'll find the middle ground between the different positions. But so far, we didn't have any indication that, people want to stall the negotiations.
Sure. And I guess just to add to that, it sounds like the Swedish presidency is keen to get to an agreement, and it sounds like we're drawing closer to one. Whether this will be the final one in trilogue obviously remains to be seen. Samuel, a question for you. Does your report, I'm thinking the algorithmic management report that you published, also include validated insights on how you decide on keeping the right balance of workers having access to the app versus the available work that's actually out there on the platform? And is there an external stakeholders? I'm assuming some kind of what kind of independent accountability mechanism have you got to ensure that the transparency is there at all times?
First, on the involvement of external parties. So the first transparency report that we published was fully done in-house without any involvement of other parties, but that's something that we're reviewing as we proceed to further editions of the report, and we think that's an important element to take into account. Now, so the question at hand is maybe more relevant for earnings transparency. So on the next report we're working on, which we plan to publish in the next few months, where we also outline, mostly outline the level of earnings that couriers are making on the platform, how our compensation model works, but also a little bit on our philosophy on how to balance the volume of available tasks with the people logged onto the platform to perform those tasks. If I may just quickly on the sort of like representation of those who work on platforms, we've seen that it's because of the institutional structure, there's been some underrepresentation of those who are generally self-employed who work on online platforms, because they're neither part of employer organizations nor part of unions, and actually we've been like relatively disappointed by maybe some of the union work around this, not all, but many unions who are actively advocating against better protections for self-employed. For example, ETIC has been calling to remove recital 23 in the proposal, which would allow platforms to offer, for example, broad insurance coverage to self-employed workers in the platform economy. So there's a bit of this lack of representation for those who are working on the platforms at the moment.
Brilliant. Thanks, Samuel, and thanks all. Just scrolling down the questions, it sounds like most of the questions have been answered with the panel, especially the quite a few conversations over control and employment status, but I think that we've covered that quite extensively. So unless there's any burning last questions, I wanted to give the floor back to Giovanna for just a concluding statement, perhaps.
Yeah, first of all, thank you so much, everybody, for super exciting discussion that has been unfolding here. And I think all of us got some interesting insights, but also most importantly, the topics that should be addressed further were flagged by these panelists. And I can tell you from the side of reshaping work that we don't plan to stop here. We plan to continue facilitating these multi-stakeholder discussions and inspiring policymaking, and hopefully making their complex work a little bit easier by giving them insights. And I also want to say that we have been working on including independent worker organizations in the multi-stakeholder dialogue from all over Europe. And we are continuing to attract more independent worker organizations next to unions, of course, which are very important. So more coming from us later on this year as we tackle new topics. I can tell you that on our plate is talent economy, everything data related, from data collection, data sharing, and evidence-based insights, as well as social protection and some toolboxes for member states. That is what we will be working on. So thank you so much from our side as well for being here for the occasion of our report launch. And Théo, thank you so much for doing a great job chairing. So please, one big virtual applause for Théo. And also big virtual applause for Reshaping Work team, Stevan, Sabina, Mariana, and Elena for putting all the hard work, and Nika for putting all the hard work into this.
Thank you, everyone.